All right, here we go. Welcome, everyone, to tonight's discussion. Can the president do that? Understanding executive power and state protections. My name is Michelle Witte, and I'll be your moderator for this evening. And I am the executive director of the League of Women Voters of the state of Minnesota, founded in 1919 to further empower voters and defend democracy after the passage of the 19th Amendment expanded votes for women. LWV Minnesota is deeply passionate about serving voters through our vibrant nonpartisan organization, committed to civic engagement through the work of 33 community-based chapters with more than 2,300 members here in Minnesota and more than 800 chapters throughout the United States. In an era of sweeping executive challenges or actions and legal challenges, it's more important than ever to understand the limits of presidential power and the role of states in protecting civil rights, voting rights, and the environment. Can the president act without Congress? Can executive orders override the Constitution? And how can Minnesota use state and local authority to safeguard our democracy? To help us navigate these critical questions, we are honored to welcome Professor Alan Rozenshtein from the University of Minnesota Law School. Hello, Alan.
Hi, thanks for having me.
Absolutely. Alan is a leading scholar in constitutional law, national security, and technology policy. Professor Rozenshtein brings deep expertise to tonight's discussion. In addition to his tenure at the University of Minnesota, he serves as the research director and senior editor at Lawfare, a non-resident senior fellow at the Brookings Institution, and a term member of the Council on Foreign Relations. Prior to academia, he worked in the National Security Division of the U.S. Department of Justice, focusing on cybersecurity and foreign intelligence. So we're all in for a treat tonight from a very busy man. So I'm so honored to moderate the session tonight, which will be conducted in a question and answer format. This webinar will also be conducted with our nonpartisan lens. Being nonpartisan means we do not endorse nor oppose political parties or candidates, but we do study, secure member consensus on, and take action on important issues. Issues themselves are not partisan, and we encourage all voters to become educated about and take action on key issues of concern that they might have by advocating with their government officials. The first step to advocacy is being informed, and that's why we're excited about our webinar tonight. So for our 500 registered guests tonight, we maxed out our Zoom license. Please know we'll be recording this session and we'll send a follow-up email to you all with a link to the recording, along with links and resources and actionable steps we can take to protect our democratic institutions and vulnerable communities at the state and local levels. You're all in webinar mode, meaning your microphones and cameras are off, but you're welcome to share any questions you have in the Q&A section of the Zoom. With only an hour, we're not likely to get to all questions, but I trust we'll all leave better informed after tonight. Okay, let's get started. Again, Alan, thank you so much for joining us. Our title for tonight, again, is Can the President Do That? This new presidential administration has raised many questions about how our government works. And tonight we're getting a mini civics lesson on our Constitution and separation of powers. We're going to start with looking at kind of executive and federal judicial power, how those powers intersect with states' rights, and how those powers further intersect with the legislative branch or Congress. And ultimately, how our own personal power as voters can still make a difference in shaping our democracy, as it always does through our votes. So question one is kind of the big one we're here for. One of the most pressing questions we have is the intersection between federal and state rights. This is really well illustrated here in Minnesota through President Trump's executive order banning transgender women from participating in women's sports nationwide, with the Department of Education releasing instructions directing K-12 and college Title IX administrators to adhere to Trump's executive order, forbidding trans women from participating in sports teams that match their gender identity. However, the Minnesota High School League officials have said that the Minnesota Human Rights Act and the Equal Protection Clause of the Minnesota Constitution prohibit discrimination against persons based on sexual orientation and gender identity, and therefore will not, or essentially cannot, enforce this executive order. The state of Maine has recently done similarly. So can the federal government override our own Minnesota protections as stated in the Minnesota Human Rights Act and Minnesota Constitution?
It's a great question. So first, again, let me just thank you all for having me here. Groups like this, these are incredibly important, and they're a real core part of our civic fabric, and it is truly an honor to be able to talk to so many of you. I'm really honored that almost 300 folks are tuning in.
500, remember 500 folks.
Yeah. 500 registered.
Yeah.
So I am for my sins a con law professor, so I will try not to turn everything into a con law lecture. But I do think it might be helpful to just say a few things more generally about the relationship between state and federal power before we get into the very specific question that you asked, which is obviously a very important one.
Great.
So the way I think about it, and the University of Minnesota Law School, I teach structural con law to first semester 1Ls, or this kind of foundation of their education. And we talk a lot about the question of federalism, this distinction that we have, not unique in America, but certainly an important part of our system, where we have both a national or federal government, and then we have the state governments. And I think about the relationship between those two sovereigns as falling into one of four categories. So one category is activities that neither the federal nor the state government can do. So for example, the First Amendment protects the freedom of religion. So neither the federal nor the state government can abridge your freedom of religion. Then there are some things that only the federal government can do, and they're outlined in the Constitution, for example. So for example, only the federal government can have foreign relations or wage war or coin money. The state governments cannot do that. Then there are things that only the state governments can do, and the federal government cannot do. So for example, the details of what is taught in Minnesota public schools, right? What the fifth grade reading curriculum, that is not something that the federal government can directly regulate. Now, I say directly because there are all sorts of spending issues that we'll talk about that get tricky, but fundamentally, there's a whole area of powers that only the states can regulate. And then there's the fourth category, which is things that both the federal government and the state government can regulate. So for example, environmental protection. The federal government can regulate environmental standards, and so can the Minnesota state government. So the question is, specifically for your question, when something falls into that last category, when it falls into the category of things that both the federal government and the state governments can regulate, who wins if there's a conflict? And the answer is quite clear, and the answer is that the federal government always wins. Article 6 of the Constitution contains something called the Supremacy Clause, which is very explicit that any laws that the Constitution, any laws made pursuant to the Constitution, which is to say any valid federal laws, supersede all conflicting state laws. And that's a strict superset, which is to say that the weakest form of federal law, so a agency regulation about something, trumps, sorry for the pun, the strongest form of state law. So my students are often surprised to hear that if some bureaucrat in the Environmental Protection Agency decides that some environmental protection policy applies to Minnesota, and the Minnesota Constitution has a strong counter right there, that federal regulation supersedes the Minnesota Constitution. So applying to your question, to the extent that Title IX regulates sports and sports by gender, then that law is binding on the Minnesota and whatever the Minnesota Constitution says cannot overcome that. Now, what's tricky, of course, is understanding what Title IX actually says, right? So if it is in fact the case that Title IX is best interpreted as forbidding trans girls from competing in girls' sports, because that is meant to safeguard the integrity of female athletics, or whatever the case is, then yes, if the Minnesota Constitution purported to contradict that, that'd be too bad for the Minnesota Constitution. But the question is, what does in fact Title IX require? And so what I expect will happen is that the Department of Education will put out, and I think it already has, or it's beginning to, put out all sorts of regulations, messages, these are called Dear Colleague letters, purporting to state what the administration's interpretation of Title IX is, and making clear that Minnesota would be in violation of Title IX if it did not operate according to those requirements. And then Minnesota Attorney General Ellison will sue in federal court, and then the federal courts will decide, not based on what Minnesota thinks or what the president thinks, but they will read Title IX and they will determine, based on their best reading of the statute, what that statute means.
Aha. So in this case, so basically, if you could sort of summarize again, what are those, specific set of laws where the federal government trumps the state government? So we're also looking at another one is the issue of things like sanctuary states, sanctuary cities, the immigration laws, things like that. Are these all in that same category of, well, very nice states, but the feds get to decide?
They are, but there's an important exception to that. And that is even in areas where the federal government has jurisdiction over something, it cannot force state governments to implement federal policy. Now, this is a subtle distinction, and it's always one that sort of my students struggle with because the case law on this is not perfectly clear. But the distinction goes something like this. Congress can enact laws of general applicability within its area of jurisdiction. And if those laws happen to require state governments to act in a particular way to comply with them, that's okay. So the classic example, there's a case called Garcia, where the federal government imposes a minimum wage. And it just imposes it generally. And the question is, well, what about state bus drivers, or bus drivers that work for a state agency? Are they do they fall under that minimum wage? And the court said, yes, they do. Because here the law is just a general law. It applies to all bus drivers, private or public. And so the state has to abide by that, even if the state would rather not. On the other hand, what the federal government cannot do, and the technical term here is commandeer, it cannot force the state bureaucratic apparatus to implement the federal law. So the classic example here, a case called Prince. This involved a firearm background protection federal law, the Brady handgun bill. And this law required, or purported to require, state police to perform background checks when individuals wanted to buy guns. And the court said that goes too far, right? It's one thing to say, you, an individual, need to get a background check before buying a gun. That's fine. But what the federal government cannot do is it cannot, and the word here is commandeer, it cannot commandeer state officials into implementing federal policy. Now, the line between a general law and a commandeering law in principle is clear, but as several years now of law students who have wept during my con law exam will tell you, right, you can come up with very nasty hypotheticals that make that very blurry. But applied to your example of sanctuary cities, there's going to be a lot of fights over what requirements does federal immigration law actually impose on state officials. I mean, state officials cannot actively interfere in the lawful activities of federal immigration authorities. But at the same time, they cannot be forced to actively cooperate. And so the question for the courts, and there's going to be a ton of litigation on this, and there was actually a decent amount of litigation in the first Trump administration, is what is that line? Where is that line between not actively cooperating with versus not actively interfering with? So that's the good news in terms of an area where there's concurrent federal and state jurisdiction, but the federal power is actually limited in a meaningful way. Here's the bad news. I talked earlier about how there are areas where the federal government does not have primary jurisdiction, where really it's a state concern. So again, the example I gave is state curricular decisions in public schools. There, however, the federal government can use its spending powers to incentivize the states to act in a particular way. So a huge percentage of what the Department of Education does is give money to states in exchange for states agreeing to all sorts of federal education standards. This is No Child Left Behind and all that sort of stuff, right? The federal government can't require the states to implement those educational standards, but it can dangle big bags of money in front of the states to do that. And so in that area, and we're going to see quite a bit of that, and actually, frankly, we're seeing that right now with the Trump administration threatening to pull funds from research universities, including public ones like the University of Minnesota, where I work, if those institutions engage in certain DEI practices that the federal government does not like. That is a very, very powerful source of authority. And so that kind of complicates this sort of story between federal power and state power.
So I heard you say, for example, the federal government can't say what schools can teach, what their curriculum is. But they could say, well, but if you're using these words, or if you're teaching these concepts, we're going to exempt you from getting federal funding.
That's right.
Okay.
That's right. And there are, as with all things, there are rules about exactly how that works, and it can't be too extreme. But the power of the federal government to condition federal spending is extremely, extremely powerful, right? And has been used, and it has been used by both sides, right? You know, a huge one of the main ways that the federal government got private universities to desegregate was by denying them federal funds. And so this is one of these, this is one of these good for the goose, good for the gander kind of situations.
So another thing we hear about is the unitary executive theory. What is the unitary executive theory? And do you expect the U.S. Supreme Court to side with President Trump on most of his executive orders or executive actions?
Yeah. So the unitary executive theory, stated simply, is the idea that the executive branch is one person. The entire executive branch is the president of the United States. And so ultimately, if the executive branch has a power, that power is the president's. Okay. So it's fundamentally a claim about the president's control over the executive bureaucracy. And it comes from, if you're looking for a textual hook, Article 2 of the Constitution, which is the part of the Constitution that sets out the powers of the executive branch, and in particular, the vesting clause, which states that the executive power shall be vested in a president of the United States, right? Notice the singular article A, right? Where this comes up is, again, in the president's ability to control his subordinates, all 3 million of them. I believe that if you sort of count the post office and the military and all the folks that work in the VA, it's like 3 million federal employees, right? And so the strongest form of the unitary executive theory says that every one of those 3 million individuals is exercising the president's power, right? Because the president obviously can't do everything himself or herself. So, like a CEO, he or she needs to hire people. But at the end of the day, right, it's the president's power, right? And that's important because that means that the president can order subordinates to do anything that is lawfully within the executive branch's jurisdiction. And I'll get to why I'm emphasizing that in a second. It also means that Congress cannot limit the president's ability to fire certain executive branch officials. So there's this extremely complicated and very important jurisprudence about what's called the removal power, the president's power to fire people. And there are all these questions in many cases that have bounced back and forth over the last 150 years about, can the president, for example, make the head of the Consumer Financial Protection Bureau protect that person from at-will firing? Or conversely, can it make it so that the president can only fire that person for gross malfeasance or incompetence, right? Probably the most important example is the chairman of the Federal Reserve, the central bank, because it is generally accepted by economists. This is one of these sort of things that basically all economists agree on, is that having an independent central bank that sets monetary policy apart from the political wishes of the president, right, who will inevitably want the central bank to juice the economy right before elections, right, which would cause inflation and all sorts of pathologies that you see in countries like Turkey or Argentina or Venezuela, or where they don't have that kind of independence. That's probably the most important example. But there are many other examples, and right now there's actually ongoing litigation because in the first month of this presidency, President Trump has fired many individuals whom Congress has by statute provided for cause removal protections from, because he argues that that is unconstitutional, inconsistent with the unitary executive theory. Now, as to what the Supreme Court will say about this, again, it's always hard to predict, right? And the nature of constitutional law, especially at the Supreme Court, is that precedent is doing much less work than they would like you to believe. At the end of the day, for better or for worse, we have a system in which we picked 9 people, 9 lawyers, we gave them black robes, and we made them philosopher kings and queens. And so they're mostly acting like statesmen, even though they'll never admit it publicly because they're lawyers, and that's sort of impolite to admit. But certainly over the last 20 years, the move has been towards a more unitary conception of the executive, with the court striking down, right, case after case after case, these kinds of removal protections, right? I don't think they're going to go all the way. I don't think there are 5 votes for the most kind of muscular version of the unitary executive, if only because I think everyone is afraid of breaking the central bank. Everyone is just afraid of breaking the Federal Reserve, right? Because it's all fun and games until you get hyperinflation. But they could go quite a bit there. The one thing I want to emphasize here is, because this is often, I think, elided in the media in an unhelpful way. The unitary executive is not a synonym for an all-powerful executive. The unitary executive is just about who is the executive branch, right? It's just about, if the executive branch can do something, right, does the president have full control over that, right? But the unitary executive is not a claim about the president's power with respect to Congress, the president's power with respect to the courts, the federal government's power with respect to the states, right? If the president tries to do something illegal, right, because it's illegal, the unitary executive won't help him, right? Now, there are other doctrines that we could talk about that are about the question of the president's powers, and in particular, the president's what's called preclusive powers, powers that are the president's alone and that Congress or the courts cannot infringe upon. But that is conceptually a totally separate question from the unitary executive, and I do think it's important to keep those things separate.
Great. Oh, okay. So it's a great segue then into kind of looking at the presidential powers with regards to Congress. So does the president really have the right to withhold federal spending on spending that was already approved by the U.S. Congress? So we think, isn't it true that under the Impoundment Control Act of 1974, that the executive branch is generally prohibited from withholding funds appropriated by Congress?
So that is correct. Congress certainly thinks that the president cannot impound funds, that the president is required, generally speaking, there are some exceptions, but generally speaking, the president is required to spend all appropriated funds. The question, of course, is Congress right? The Impoundment Control Act is itself unconstitutional. It doesn't really matter what the Impoundment Control Act says. Mm-hmm. The history of this is, I'll admit, somewhat complicated. If you go back all the way the founding of the Republic, there are examples of early presidents, President Jefferson, President Andrew Jackson, impounding funds. That was controversial at the time. There were no conclusive Supreme Court opinions one way or the other. That was also quite a long time ago. I will say the modern consensus ever since Richard Nixon is that, to the extent the president has an impoundment power, it's very, very narrow. And it has to be understood in the context, in the broader context of the president's obligation, and this is also in Article 2 of the Constitution, to, quote, take care that the laws be faithfully executed, right? Mm-hmm. And so the question is, how much space, if any, does that leave for impoundment? I think most people on sort of all sides of this debate will agree that there must be some impoundment power, because if Congress tells the president, spend $1 billion to build this warship, and it just turns out that the warship only needs $500 million. I mean, it never turns out that way, but imagine it turned out that the warship only needed $500 million. It seems very silly to then light the other $500 million on fire, right? So there's a general consensus that as long as the president is acting in good faith and really trying to further the will of Congress, because Congress can't legislate perfectly and they can't imagine every contingency, and there has to be some level of delegation. That's kind of why we have an executive branch, because Congress can't do everything itself. There must be some level of impoundment. But the much stronger version of impoundment that the Trump administration is putting forward, where an appropriation says USAID shall spend $500 million on such and such, right? And not just on some generic statement like furthering Americans' foreign policy, which the president could say, well, in my judgment, it doesn't further America's foreign policy, so I'm not going to spend it. But like actual line items, right? You have to spend $10 million on this group and $12 million on that group. For the president to say, I just don't want to, it's very hard, I think. And I have not seen, even among sort of conservative constitutional law scholars who have no problem sticking their neck out for all sorts of interesting pro-executive power theories, I have not really seen a particularly good argument for how that is compatible with the overarching obligation that the president has to, again, take care that the laws be faithfully executed. But this is something, as with many things in the next couple of years, where ultimately the Supreme Court will have to step in and clarify.
So in this case, then, what we're seeing is, I mean, right now, right, there are organizations saying, wait, you said, there was an actual, the federal court said you need to return these federal funds or get these federal funds going again, yet the administration has not. What happens if the executive branch doesn't honor what the courts are saying, the federal courts are saying, is which sort of what we seem to be seeing right now?
Yeah. So let me first say what we seem to be seeing, because that's a little tricky and I think actually very important. And then I'll kind of ask what I think is the sort of heart of your question.
Yeah. Great.
What happens when we hit DEFCON 1 and the president says,
Yeah.
no, I'm not interested in obeying court orders. So it's not exactly clear what's happening right now. There is a bunch of litigation. Some of those orders from the courts are themselves a little unclear, in large part because the courts themselves aren't entirely sure what's going on, because it's not clear that the executive branch is entirely sure what's going on. And so you have some extremely awkward exchanges between judges and Justice Department lawyers, where the judges ask, for example, who is the administrator of DOGE? And the lawyer says, I don't know the answer to that question, which is an odd thing to say, but it is the case. Right now, the administration is maintaining the position that it is complying with federal orders, with federal judicial orders. Now, it is doing so in the most, I don't know, it's doing so in the way that my 4-year-old complies with eating broccoli, right? Which is the absolute minimum possible amount, right? He eats a molecule of broccoli and he says, I've eaten broccoli, right? And so that's annoying. But rhetorically, that's actually still important. Because rhetorically, and as a matter of norms, and at the end of the day, a constitution is not a self-executing document, right? Or rather, a constitution is only as strong as the sort of societal norms that are around it, right? There's the whole point of a constitution is that there's no overarching authority to enforce it. As a matter of norms and public messaging, the administration is not claiming that it can disobey federal court orders, right? And there is a process by which federal courts can drag lawyers back into court and say, I don't think you're complying with my order. You will comply. I will throw you in jail if you don't comply, right? And so I think we still need to see that process play out, right? But at the same time, parts of the administration, sometimes very inelegantly, in the case of Elon Musk, who sells all sorts of interesting things on X, and sometimes much more carefully and intellectually, as in the case of Vice President Vance, who is, whatever one may think of him, an extremely intelligent, Yale-educated lawyer, right, who's very smart. They are setting the rhetorical stage for potentially disobeying federal court orders. So after one of these restraining orders that a federal court issued on some administration policy, I've sort of lost track. There's so many of these lawsuits flying about. Vance went on X and he said that, and I'm paraphrasing here, it is illegitimate and unconstitutional for a federal judge to interfere with the legitimate exercise of presidential power. And everyone freaked out about that. If you read that phrase very carefully, it's actually not saying anything at all. Because of course, if in fact a power is legitimately the president's, it would be illegitimate for a federal court to interfere with that power. The question, of course, is what counts as a legitimate exercise of executive power and who gets to decide that question, right? And so you can see they're leaving themselves, right? A little bit of breathing room here. So what happens, though, if this goes up to the Supreme Court, right, on one of these issues, and the court says, you can't do this, right? And now there's no one to appeal to. The Supreme Court, there's a famous phrase where the Supreme Court says, we are not final because we are infallible. We are infallible because we're final, which is to say someone has to be the Supreme Court, right? The buck has to stop with someone. What will happen? Will the president obey that? There's a famous, perhaps apocryphal story from the Andrew Jackson administration where Chief Justice John Marshall, probably the most famous and most important Supreme Court justice in American history, told the Jackson administration to stop stop the expulsion of a Native American tribe off of their land. And Jackson, again, maybe this is apocryphal, but it's one of those sort of too good to check kind of quotes. And it's certainly gone down as an important part of the legal firmament. Said, well, Mr. Marshall has his opinion. Now let him enforce it. Basically, right? It's a little bit like Stalin's quip when told that the Pope didn't like what he was doing, which was, well, how many divisions does the Pope have? Right? The idea here is that the courts are the final word, but only because the guys with the guns, right, are willing to abide by that. And if they stop being willing to abide by that, then we are in a constitutional crisis, right? Now, that doesn't mean that the world ends the next day, we're all under martial law, we fall into some sort of North Korean totalitarianism. But that does mean that if that happens, a Rubicon has been crossed, a Gordian knot has been cut, use whatever cliche you want. But a fundamental part of the machine that is the Constitution has broken, right? Mm-hmm. And we just don't know what happens at that point.
Right. Is there a particular reason they would want that? I guess I'm curious as to, when you look at all of this and think, I would imagine Wall Street isn't going to like that. I would imagine the economy isn't going to like that. I mean, is there any reason that you can surmise that they would want that?
I mean,
moment.
They being the administration?
Right. Mm-hmm.
I mean, authoritarianism is a lot easier when you don't have to listen to the courts.
Yeah. There we go. I sense a new musical maybe here when we come out the other side, right? To teach us these lessons. All right, thank you. Okay, another big question. A federal judge recently declined to temporarily block Elon Musk and his Department of Government Efficiency, or DOGE, from accessing federal data systems at a slew of executive branch agencies, thwarting a lawsuit filed by a dozen states' attorney general, including A.G. Ellison. What do you make of this decision and the legal premise of someone like Elon Musk accessing our data without any authority given him by Congress or accountability for his actions?
Yeah, so this is where we could really get into the weeds and bore everyone to tears, so I will try very hard not to. The decision declining to enjoin what DOGE is doing, and there are lots of these kinds of litigations. There are decisions about DOGE's access to sensitive data. There is litigation about whether Elon Musk is unconstitutionally exercising official power since he's just some guy, right? He's not been confirmed by the Senate or anything like that, or nominated to any particular position, or whether that violates what's called the Appointments Clause in the Constitution, the process of Senate confirmation, all these litigations. There's the merits question, right? Which is the one, in some sense, that we actually care about, right? Can DOGE access all this data from across the federal government? Can Elon Musk behave in the way he's behaving, given that he's not been Senate confirmed? But then there's a set of very complicated procedural traps that you have to navigate in order to get into court and even be allowed to raise that question. And a lot of them fall under the general concept of what's called standing. And this is a principle that not anyone can simply raise any issue in federal courts, right? I am a con law professor. I care a lot about this stuff. I teach about this stuff. I think about this stuff. I dream about this stuff, right? I am a lot invested in this stuff. But I cannot just walk into the courthouse, right? The federal courthouse here in the Twin Cities, and sue Donald Trump or Elon Musk or whatever for a whole variety of constitutional sins that they may or may not have committed. Mm-hmm. Because I have not been personally affected in some special way, right? That makes me the appropriate plaintiff for this. Now, there's a complicated reason why courts require these standing doctrine. It's largely to prevent every basic kind of policy and political dispute from ending up in a federal court. It's a kind of way of, in some ways, artificially preserving the court's own health by not allowing it to be drawn and dragged into every conceivable fight in this country. And what happened in the lawsuit that you referenced was that the judge says, look, you haven't proven to me that you, right, you attorneys general, or specifically the citizens that you represent, have actually been injured in a concrete way. Yes, it's not great if all this stuff is happening and stuff like that, but anyone could make this claim, or you're just generally upset at what is going on. So I wouldn't read too much, I think, into these procedural decisions, because at some point, something will break, right? Someone's data will be actively mishandled. Some payment that someone is owed pursuant to a federal contract will not be deposited in their bank account. And then that person will be able to walk in and say, right, I'm missing my $10,000 payment, right? And I think I'm missing it because this whole thing is unconstitutional. And so the flip side of the fact that not anyone can go in claiming some generic constitutional law argument, the flip side of that is an individual can walk into court, right, saying, I'm owed $100, right? And that case can go up to the Supreme Court and create constitutional law for 100 years, right? Because the court might need to decide some extraordinarily important question of constitutional law to vindicate someone's $100 claim, right? And so that's kind of the trade-off. That's kind of the trade-off here. So it will just take some time to find the right plaintiffs who can really point and say, no, I'm not just generically upset. Like, I'm specifically been harmed, right? So you need to hear me out because I'm owed my $100. And if that means you have to declare the entire executive branch unconstitutional, then you got to do it because I'm owed my $100.
So using that, then I guess, one of the questions we had was also about the SAVE Act, the Safeguard American Voting Eligibility Act, which would essentially, require everyone to have proof of citizenship, and it would get rid of voting registration the way we do it as the League of Women Voters, right? Everyone would now have to go before an election official and show these documents. So I would imagine in that case, we would have really good standing to say, listen, this is, we're no longer allowed to register voters. We're no longer, able to support voters the way we did. Would that be an example? Would we have good standing in that case to bring a law?
You certainly would have a colorable argument for standing. I don't want to say yes or no, because the closest I got to a nervous breakdown in law school was the night before my federal court's jurisdiction exam when I was trying to understand standing. It is, I think, maybe the most formidable doctrine in American constitutional law. It's absolutely brutal. But yes, that is the kind of situation in which the League of Women Voter, or a voter, right, who, can't find their birth certificate, right, would be able to have standing. Of course, that only gets you into federal court. Then you have to actually win your case, which is a whole separate conversation.
Right. So, Alan, you also sort of somewhat of a cybersecurity expert and work in government technology. And I'm wondering if you could comment on any possible concerns you might have overall about DOJ, the way it is now accessing our federal databases.
It's very bad. I did cybersecurity in the government. I started my career off as a cybersecurity scholar. I still think about this stuff. It's also personal for me. I am the lucky recipient of 2 free lifetime credit monitoring subscriptions from the federal government because the Chinese government stole my security clearance data that many times. And not just me, right? I'm not terribly interesting, but me and my, a million of my best friends in the federal government. So this is not like a purely hypothetical question for me. What DOJ is doing from a cybersecurity or just an information security or just a basic IT perspective is horrifying. I mean, is absolutely horrifying, right? They are pulling all sorts of data, much of which is sensitive. They're dragging it around. It's already raising massive concerns across the federal bureaucracy. DOJ basically, and Elon Musk bragged about this recently, sent an email. I'm sure many of you have read the news about this to all federal employees saying, please respond with the 5 accomplishments you did last week, right? Because who doesn't like corporate make work? Or, this will be considered your resignation. The Department of Health and Human Services sent an email to its employees saying, please don't respond. And if you do respond, please be aware that foreign nations will almost certainly be reading what you respond because you're going to be responding on unsecured email servers, right? It's an amazing situation here, right? There's a cybersecurity concern. Again, there's also just basic keeping the trains running concern. There are reports that Doge has access to Treasury's payment system, which is very scary because those things are old, they are creaky, they are kludgy, they are written in programming languages that are older than many of us on this call. And you break one thing and the US government defaults on its debt obligations. So whether from a cybersecurity perspective or from an IT perspective, this is being done in an extremely, extremely concerning way.
So my blood pressure is pretty high right now, Alan. So do you...
I am afraid it should be.
So I guess, one of the questions we had before we get to some questions from our guests is, what question haven't we asked that you think we should? I mean, are there other things we should be looking at? And if you have anything on a positive nature, we'd love to hear it. But I'm wondering what else is happening right now of note to you and what your students and you are talking about.
Sure. I mean, to me, like I tell my students, the reason we have constitutions, the reason we have rule of law is because it's much better to do it that way in a diverse country of 350 million people than shooting each other.
Mm-hmm.
But it also means that at the end of the day, you cannot get away from the fact that it's important that the guys with the guns be bought into this system. Mm-hmm. Because there's no magic here, right? No one will save us, right? Now, we have, fortunately, a very long and healthy institutional tradition of nonpartisan law enforcement and military. What is raising my blood pressure and keeping me up at night is how quickly that could change and how much it appears to be the case that the administration wants to change that. We have a U.S. attorney in D.C. that refers to himself unironically as Trump's lawyer and sends threatening emails to journalists that he doesn't like. We have Kash Patel, who is this is a family show, so I'll just say he has an interesting relationship to the truth. As the director of the FBI, we have Pete Hegseth, the Secretary of Defense, firing military judge advocate general military lawyers because, well, he doesn't want things like the laws of war to get in the way of war fighting. Mm-hmm. That is what really scares me. As to what gives me hope, I don't think these people are very good at their jobs, to be perfectly honest. I write for a publication called Lawfare, and the editor-in-chief, Ben Witte, wrote what I still think is maybe, he wrote this during the first Trump administration, I still think is maybe the best encapsulation, which is malevolence tempered by incompetence. Right? I think that is fundamentally the story of this group of individuals. They don't seem to be very good at their job. They seem to have profoundly misunderstood their quote unquote mandate, which was to bring the price of eggs down, as far as I can tell. Right. And everything that they are doing, from tariffs to scaring financial markets, is simply going to lead to inflation. The Republicans basically don't have a House majority. I was reading 30 seconds before we got on that they called off a budget vote because they don't have any votes. And so everyone's like, Congress people are just literally driving around the Beltway trying to figure out if they have to go back to Congress, right? And if we've noticed anything in the last 15 or 20 years is that thermostatic equilibrium, right? The idea that the American people, it's not clear what they want, but it's clear what they don't want, and that's the thing they have, is very strong. So it's almost certain that the 2026 midterm election will be very unpleasant for the Republicans, right? The Democrats will almost certainly retake the House, and then they will have at least one branch or half a branch of government in power. And so I wouldn't give up on democracy quite yet, but it makes me very nervous. And the possibility of civil unrest and state violence also makes me quite nervous. I don't find sort of Civil War talk particularly helpful. I don't think it's analytically very compelling either. We don't have the kind of demographic split that really drove something like a continental civil war. But what we could have is state violence, a lot of unrest, and that is just a very unpleasant thing.
Any good advice to give to people who want to ensure the strength of democracy?
Well, I show up to events like this. I mean,
Yes.
just care.
Yeah.
Don't give up.
Right.
Stay informed. Try to take a big tent approach. I think there are a lot of people who have buyer's remorse right now at what this administration's doing. I think it's very easy and tempting to mock those people because it's not that surprising what happened. I think that temptation should be resisted at all costs. Right now, we need a sort of coalition of all democratic forces. And I think keeping that in mind and that being far more important than any particular policy disagreement is, I think, the key here. The other thing that I will say is I do think that there is one silver lining from this election. And again, this is a nonpartisan group, and I'm not particularly partisan myself. I come at this again much more from a sort of small d democracy, rule of law kind of perspective. One thing that did give me a lot of hope was, how do I put it this way? Just how poorly Democrats did with traditional Democratic constituencies, in particular young people and minorities and people of color. Which again, it sounds like an odd thing to say. But the thing that I've been most scared about is that America would polarize on racial lines. And that if that happened, as America became went through a complex racial demographic transition of no longer being a majority white nation, you'd have a situation where the Republican Party would turn very much against democracy because they'd know that they couldn't win, right? The fact that the Republican Party is becoming much more multiracial is, from the perspective of a democratic strategist, an absolute disaster, obviously. From the perspective of someone who's concerned fundamentally about keeping the democratic game going, right? Concerned more about that than about any policy position is an enormous relief, right? Because it suggests that we're entering into a situation, not that our politics is going to become post-racial or anything. I'm not naive, but that both political parties can contest for broad democratic, again, small d democratic majorities, right? Which means that both parties are invested, right? And why, just to go, for example, back to your point about voter ID, I'm much less afraid of that than I think a lot of Democrats are. Not because I'm a particular fan of voter ID laws. I think there are ways, if you do it correctly, that it's okay and you can provide voter ID. But that it's not actually clear that the Republicans benefit anymore from strong voter ID laws because their voters are increasingly the kind of quote unquote low propensity voters that often were part of the Democratic coalition. Again, the more you move into that kind of world, it's not that politics becomes nicer, it gets just as nasty, but it becomes less existential because every side knows that it can actually compete. And so it might as well compete rather than try to blow the whole system up. Now, so what that means to me is that if we can get past these next 3.5 years, right, and in particular, Donald Trump's extremely self-absorbed and kind of narcissistic conception of what's good for America, which is to say what's good for him. If we can get past that and get to a world of Ron DeSantis's and J.D. Vance's and Nikki Haley's, whatever you think of them as politicians or individuals or policy thinkers, I think you can be much more optimistic for a return to merely nasty politics rather than existential politics.
Ooh, a very, very insightful. Thank you. We do have time for some questions. So I'm going to ask Sam Strukins, our Civic Engagement Director, to pop in. He's been monitoring the Q&A. We have time for a few questions. You want to hit one? Hit one out there, Sam.
Yeah, thanks, Alan, and thanks, Michelle. Let's talk about the environment. Minnesota has standards and rules that are more stringent than federal laws, including an environmental review. Would the federal government be able to, say, approve a mining permit without fulfilling the environmental review requirements under the Minnesota Environmental Response and Liability Act?
Yeah, so this is an excellent question. And here there's no one size fits all answer. And I should say I am not an environmental law specialist, so I don't want to get too far over my skis. The question that I need to look into is exactly what does the federal environmental law say? Does it impose a ceiling? Does it impose a floor, right? That preempts any state law that tries to go lower than that? or does it also impose a ceiling, right? Different, and that's not a constitutional question. That's a question of reading the statute extremely carefully. And different statutes and different parts of statutes, and different parts of statutes can take different approaches on that. It also depends, are we dealing with state law or are we dealing with federal law, right? The farther you go west in the United States, the more land that the federal government itself owns, to the point where in a state like Nevada, like 90% of Nevada land is actually federal land. It's not state land, which raises all sorts of interesting questions. I think most of Minnesota actually belongs to the state of Minnesota. So the federal government would not have the sort of plenary authority that it would have if it owned that land. But I apologize for the non-answer. This just gets into the details in environmental law that I wouldn't want to make up on the spot.
Sure. Yeah, we can come back to that as well. Next, the administration appears to be eliminating Black Americans from jobs as DEI hires with no other cause for removal, apparently. Are there any protections for workers who were fired under these circumstances?
Well, there is we have a civil service protection system. Now, going back to our discussion of the unitary executive, a very strong version of the unitary executive theory would also find that those protections were unconstitutional. But those protections still exist, and there's not a lot of indication that there are 5 votes on the Supreme Court to totally gut them. And so right now, there's litigation going on challenging the firing of probationary employees, for example, whatever their race may be, just on the grounds that you just can't do that. There are these statutory protections. With respect to specifically claims about racial discrimination, right, singling out Black or Hispanic or other sort of minority employees or female employees because of their demographics, that would fall afoul of the Equal Protection Clause of the 14th Amendment. Where it gets more complicated is proving that that's why you were fired, right? It is within the power of the presidency to say, we don't want, just as Joe Biden could come in and say, I think DEI is very important. I want to staff that up in my administration. The next president come in and say, I don't think DEI is good. I want to fire those individuals, right? Now, if those individuals are disproportionately one race or another, that gets into tricky legal territory. But it again depends a lot on specifically why those individuals were fired and what, maybe more practically, those individuals can prove in a court of law.
Sure. Thank you. That's very clear. Next, could you talk more about the timing of court cases and when we can expect challenges to be heard in decisions on federal overreach and DOJ actions? Moreover, if the president chooses to ignore a court order, what options does the court have to ensure compliance?
Yeah. So on timing, I mean, we're already getting decisions. We're getting temporary restraining orders. We're getting appeals to that. We got an appeal actually all the way to the Supreme Court that was denied for procedural reasons. So there's just going to be a constant drumbeat, right, of these decisions. The question is, the decisions are not finalized until the final authority of the Supreme Court weighs in, and that can take quite a long time. I would be surprised. One can imagine if things went quite quickly, maybe we'll hear something in 2020. Maybe the Supreme Court will hear cases in 2026. We probably won't have like really substantive Supreme Court decisions on these core structural constitutional law questions, I would guess, until the summer of 2026. But you never know. The Supreme Court can act extraordinarily quickly when it wants to, and one can imagine some emergency situation. Now, again, what can the courts do if their views or if their opinions are not, or if their orders rather are not being abided by? I mean, they have remedies. They can yell at judges. They can impose contempt. They can order people to be put in jail. But the Marshal Service, which is the court's enforcement arm, is run by the Department of Justice. The answer is nothing, right? At the end of the day, a legal system, a constitutional system works because earlier I talked about because the guys with the guns buy into it, but more fundamentally, because enough of a critical mass of the population buys into it that the system functions, right? So if we get to that critical point and the Supreme Court unequivocally orders the president to do something and the president says, not going to do it, right? Nothing short of a general strike, mass unrest, a real popular mobilization that brings this country potentially to a crisis point, I think will suffice. And unfortunately, and this is one of the weaknesses of our system, we don't have a version of what parliamentary democracies have, where you can have a vote of no confidence in the government and you can have snap elections and you can deal with that kind of impasse, right? If in 2026 we have some constitutional crisis, there's no election until 2028, right? And at that point, I have friends in the political science department who are emailing me and they're texting me and they're saying, hey, what do you think about this case? It'll go up, and how will justice so vote? And at some point I just got very frustrated and I said, dude, you're the political scientist. At some point, this no longer becomes a legal question. It becomes a political question, right? A question of politics and sociology and mass mobilization. I have no wisdom here, right? I can only tell you how the rules of the game ought to operate. But if the players on the field say, screw it, I'm just an umpire. I'm no use to anyone anymore.
Excellent. I wish we had more time for more questions. I thank you so much, Alan. I think, and it's a really good segue to what are we going to do and how has it always been where this is where the people become the power, right? I personally was arrested at the CIA when we had our illegal wars in Central America, and I was water cannoned off the fence trying to get into the National Guard to stop them from illegally going to support the Contras. So sometimes we have to put ourselves out there, right? And I think about the civil rights, and we're sitting here in the anniversary of Selma. I like to talk about John Lewis all the time, but imagine him on the Pettus Bridge being clubbed. I mean, those are not images we want to put ourselves in, right? Those are not stories we want to have happen or put ourselves in. But people have fought back against some very serious times. And so I just want to thank everyone for taking this first step today to be here to get educated. We really, it's hard to have the facts right now too. So we're really appreciative of learning. Reminder that we'll be posting a recording of tonight's webinar on our YouTube page, which will be on our website at lwvmn.org. It'll be in the past events section. You all did the first part tonight, educating yourselves, but the work doesn't stop. Like we said, each of us has a voice, and it is a great time to become a member. Of course, we want you to join the League of Women Voters, but any group that right now joining is putting you in touch with people who are working together and can be called into action as we need it. Our LWV members keep the momentum going right now. We have a special Take Action page for all kinds of actions to support communities and democracy. And we have Fired Up Fridays to learn how to take action. So use your voice. This is the time, as Alan said, write a letter, stay involved, use your town square to influence people. Democracy is always strongest when we all show up. And I always say the best action to take is the one you will do, right? So finally, I do want to end with the Honorable Civil Rights Leader and Congressman John Lewis. He's always my guiding light. And in the honoring Selma anniversary, so many great things he said, but I love ours is not the struggle of one day, 1 week, 1 year. Ours is not the struggle of one judicial appointment or presidential term. Ours is the struggle of a lifetime or maybe even many lifetimes. And each one of us in every generation must do our part. So a lot of us know that democracy, every right we have today is because someone fought for our rights to be here. We have to do our part now for those coming up behind us. So thank you all for doing your part tonight. A special thank you again to Professor and young father of young children for taking time in this evening. Professor Rozenshtein for being on the front line of teaching new law students about the principles and promise of our democracy. Thank you all. Stay strong, everybody, and good night.